Hello, everyone. I am Dorian Peters, the 2021 CCCBA president and an attorney at Atkinson, Anderson, Loya, Rudin, Romo. On behalf of the Contra Costa County Bar Association, I would like to welcome you to this keynote session of the 27th Annual MCLE Spectacular.
Thank you for welcoming everyone. If we wait a couple minutes, we'll have everyone will be able to get in.
All right.
So welcome everybody. And we'll get started in just a minute. We've got about 50 people in. We probably have another 50 or so more. So takes a couple minutes. Hello, everyone. I hope everyone's ready for an informative hour with Dean Chemerinsky. We'll get started here in just a minute as soon as everybody has been accessed the meeting or the webinar.
So Ann, how about we get started and then we can get through the intros and everything.
Yep. All right. Dorian, welcome everyone. I'm going to introduce Dorian Peters, CCCBA Board of Directors President.
Hello, everyone. I am Dorian Peters, the 2021 CCCBA President and an attorney at Atkinson, Anderson, Loya, Rudin, Romo. On behalf of the Contra Costa County Bar Association, I would like to welcome you to this keynote session of the 27th Annual MCLE Spectacular. We hope you have enjoyed this morning's program. Today, we will hear from Erwin Chemerinsky, Dean of Berkeley Law. Before we get started, though, I would like to introduce Joanna Barron of ADR Services, Inc., who is sponsoring this program today.
Thank you, Dorian. Good afternoon, everyone. My name is Joanna Barron, Vice President of ADR Services, Inc., and I'm here to tell you a little bit about our firm. ADR Services had very humble beginnings. After personal litigation indoctrinated our founder and president, Lucy Barron, into the legal system, she recognized the value and importance of alternative dispute resolution, an emerging field at the time. After spending countless hours studying private dispute resolution, Ms. Barron, who was a single mother of 7 young children and a non-lawyer, contacted a list of retired judges and invited them to join her fledgling panel. Enticed by her vision and intrigued by her determination, 8 retired judges initially agreed to work with what has now become the fastest growing ADR provider in California. Opening its doors in 1994, our company started as a single subleased office space with access to just a pair of conference rooms. Now, 26 years later, ADR Services, Inc. operates 7 offices across the state with over 140 retired judge and attorneys on our panel. We have now become the preeminent alternative dispute resolution provider firm in California, and our mission is to provide the highest level of quality, integrity, and efficiency in dispute resolution services by offering an outstanding group of mediators, arbitrators, referees, and private judges, combined with superior case management and progressive technology. This year, we are projected to handle over 13,000 brand new cases, and we hope to continue to help you in resolving your disputes, whether it be in person or by Zoom. Lastly, I wanted to introduce our newest panel members, including Justice Ming Chin from the California Supreme Court, Brad Benning, based in our San Jose office, Steve Block, based in Sacramento, Peter Smith, and Jerry Green. Thank you to the Contra Costa County Bar Association for putting on such a valuable and engaging program, and we are very proud to be included and to support this. And with that, I will turn it back to Dorian, who will introduce our impressive keynote for today's presentation.
Thank you, Joanna, and thank you to ADR Services, Inc. for your sponsorship of this program and your continuing support of the CCCBA and the MCLE Spectacular. Let's get started with our keynote program. The Internet and its relationship to democracy, with our distinguished speaker, Erwin Chemerinsky, Dean of Berkeley Law, and the Jesse S. Choper Distinguished Professor of Law. Dean Chemerinsky has a long and distinguished career in legal education, is the author of 11 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction, and is the author of more than 200 law review articles. He has been named the most influential person in legal education in the United States. It's all yours, Dean Chemerinsky.
Thank you so much for the kind introduction. Thank you for having me with you today. I wish we could be together in person, but I'm glad at least there's the opportunity to share this time by Zoom. The topic could not be more important, looking at the internet and social media in its relationship to democracy. The reality is that the internet and the social media are the most important changes in communication since the development of the printing press. In some ways, we've entered the golden age of free speech. If 30 or 40 years ago, free speech advocates had tried to engage in science fiction and think of media that would make it possible to so quickly reach a mass audience, media that would make it possible to so immediately access information, I doubt in their wildest dreams they could imagine where we are today. For so much of world history, the problem with regard to the media was scarcity. Even when there were more newspapers, there was still a finite number. The broadcast media, because of limited frequencies, is inherently scarce. And yet no longer do we face scarcity with regard to access to information or avenues for communication. In 1969, in Red Lion Broadcasting versus Federal Communication Commission, the Supreme Court upheld the constitutionality of the fairness doctrine that includes the right of people to reply to attacks. The Supreme Court did so based on the scarcity of the broadcast medium. And yet no longer do we face scarcity. Ironically, now it's the lack of scarcity, the seeming endless opportunities for communication. This was calling for and even demands for regulation. So I thought I would address 3 points today. First, I want to talk about why we should regard the internet and social media as providing us a golden age for free speech, but also the problems that comes from having this plethora of media available to us. Second, I want to focus my comments on Section 230 of the Communication Decency Act. There's a book that talks about how the words of Section 230 are those that made the internet. I don't think it's hyperbole. Section 230 is also responsible for a lot of the problems with regard to the internet and social media. So I want to talk about, can it be fixed? And third, I want to talk about some of the underlying problems with regard to the internet and social media for democracy, ones for which there are no obvious solutions, but ones that are deeply important for American society and the world. I thought I would talk for about 45 minutes and then use the remaining time for any questions. So let me start with the first of those points. Why the internet and social media have truly created a golden age for free speech, but the problems it poses too. I would identify 3 reasons why I believe that the internet and social media are the most important developments as to expression since the printing press centuries ago. One is that it's democratized the ability to reach a mass audience. It used to be that to reach a mass audience, somebody had to be rich enough to own a newspaper or to get a broadcast license. Now anybody who has a smartphone, or even access to a modem in a library, can immediately reach a mass audience. No longer is the ability to reach a large number of people in the hands of the few. Think of Twitter and the ability of people to have hundreds of thousands, millions of 10 millions of Twitter followers, the size of an audience that previously only a large newspaper or a broadcast station with a powerful frequency would be able to have. There's a tremendous benefit to having a medium where we democratize the ability to reach a mass audience. I remember when I first taught media law in the early 1980s, so much of the discussion was based upon the relative scarcity of voices. At that time, there were 3 television networks, ABC, NBC, and CBS. Fox was just beginning to develop as a 4th network. And there were benefits to that, to be sure. I think there was something unifying in the country, that we were all getting our news from relatively few sources. Some cities had multiple newspapers. When I was growing up in Chicago, there were 4 major newspapers. When I moved to Los Angeles in the early 1980s, there were 3 major newspapers. And we've seen, especially in small areas, newspapers fail. But now we don't have to worry about just relying on 4 networks or a handful of newspapers. There's the ability to so many people to reach large audiences. And yet there's a downside of this too. It's a problem of what some have called cheap speech. It's very easy for any of us to speak with almost no costs. Well, the speech can be uplifting, can be enlightening, but it also makes it possible to harass a significant number of people, especially women and people of color, are subjected to harassing behavior over the internet. A significant percentage of women college students have said they've been subjected to harassing behavior over social media. Bullying can go on over social media. And we certainly see that too in schools. False information can be quickly transmitted over the internet. And the false information might be injurious to reputation. The false information can do great harm. If false information is spread with regard to a public health crisis or about vaccines to help solve it, there can be great injuries done to people. Privacy can be invaded. There's even a word for this, doxing, where private information is sent. And once private information is sent, there's no easy remedy. More speech doesn't cure the invasion of privacy. So the ability of so many people to reach other people has a huge benefit, but there's also real costs in it. I worry too that it does enhance the divisions in our society. American society, as everyone knows, is more polarized than it's been at any point, I would say at least since Reconstruction, before that, the Civil War. I do not blame the internet and social media for all of that polarization. The reality is, I think, even if there were no internet, even if there were no social media, there'd be a great deal of polarization in our society. There's just fundamental disagreement about basic value choices. Talk radio, specifically conservative talk radio, long precedes the development of the internet and social media. And yet, I think that there is a way in which the internet and the social media do contribute to polarization, in part because the ability of people to seek out and receive voices that they already agree with. It's no longer the case that we're all getting our news from a few sources. If you're conservative, you probably have your favorite news outlets. If you're liberal, you have your favorite news outlets. And so it's an ability of people to hear the messages that reinforce what they already believe. Also, I think that the internet and social media has led to much more vitriol in communication than we've ever seen before. I think there has been a coarsening of discourse in our country. As a result, I think that there are adverse consequences to the democratic process. So I strongly believe in the benefits of the internet and social media and democratizing the ability to reach a mass audience, but I don't minimize the harms either. A second way in which the internet and the social media have dramatically changed communication is by giving people access to almost unlimited information and making it permanently available. It used to be that in order to do legal research, one had to go to a law library. When I was in law school, when I was a young attorney, For any research I wanted to do, I had to go sit and pull the books off the shelves. My students no longer remember what digests were or what Shepherd's was. Now, of course, I do all my legal research right from my computer, going onto Westlaw or Lexis, finding not just all the cases in the country, but the law review articles, the treatises as well. But it's not just about legal research. The reality is we all have access to unlimited information just at our fingertips. I am sure that each of you has had the same experience I have had of a dinner conversation where a factual matter is in dispute. At my house, it's almost always about sports and arguing over something with regard to, say, baseball statistics. Now, used to be we'd have to go find the baseball encyclopedia, and rarely did somebody have the energy. Now somebody just takes out a phone and looks it up. And that's, of course, just an example. We have access to all of the great collections in libraries and museums around the world. And that's a wonderful thing. But once something's on the internet and social media, it's likely there permanently. It's probably been recirculated or retweeted. And once that's happened, it's hard to take it down. Let me give you my comparison. It used to be that if something defamatory was said about a person, a couple of days later, the newspaper was at the bottom of a birdcage. To be sure, the false information that hurt reputation could be circulated. I don't minimize the detriment of defamatory speech. But on the other hand, in order for somebody later to access it, they'd have to go to a library. They'd have to find it on microfiche or microfilm. Now it's forever there in the internet. So when you think of some of the things that I talked about earlier, information that invades privacy, speech that's defamatory, speech that's hateful, harassing, or bullying, it's there and it's there forever. A third aspect of the internet and social media that's important is the way that it transcends national boundaries. Of course, when we were dealing with newspapers, they were available where they were circulated. It might be possible to get major newspapers in other countries, but it would be very difficult to do so, and only certain newspapers were available. Broadcast frequencies were limited in terms of scope. You generally couldn't get them beyond a particular area. So countries had much more ability to control the information that was received by their citizenry. The internet changes all of that. The internet makes it very difficult to stop speech at national borders. The Supreme Court estimated that about 40% of the sexually explicit material on the internet comes from foreign countries. We obviously can't control what comes from foreign countries. It makes it very difficult if the government wanted to try to regulate pornographic material over the internet. This sometimes has been seen to benefit in terms of not being able to stop speech at national borders. When the revolution began in Egypt, one of the first things that Egypt decided to do was close down the social media and the internet. But people had satellite phones and they were able to access the information. Even in countries that have authoritarian regimes, they're not able to exclude all of the speech from the internet and from social media. And that can be a tremendous benefit. And certainly in this country, the ability of the government to control what we see and what we hear is more limited now than it's ever been because of the availability of the internet. But as with the other benefits of the internet, the cost to this as well. The ability of others in foreign countries to influence our elections exists like never before. Now, to be fair, the United States, especially since World War II, has often done things to try to influence the outcome in foreign elections. But now what we've seen is that foreign governments are trying to influence the outcome of elections in the United States. We know from the Mueller report that there was a systemic effort, a pervasive set of actions taken by Russia to influence the outcome of the 2016 presidential election. Likewise, if you read the congressional reports, this is not a partisan statement. I don't think there is any factual doubt that what Russia did was try very much to influence the election in favor of Donald Trump. Maybe, given how close the election was, Russia's efforts were decisive. But even if they weren't decisive, it was certainly a concerted action. We know that there were efforts by Russia and China in the 2020 presidential election that were apparently less extensive and less successful. But the reality is we can't stop speech at the borders of the United States. That might have benefits, but it also has real costs. So I've tried in the first part of my remarks in talking about the internet and social media democracy to point to the huge benefits, but also the substantial problems. It takes me then to the second part of my remarks, which focus on Section 230 of the Communication Decency Act. I share the view of those, such as the book that I alluded to, that the words of Section 230 really are the ones that allowed the internet and social media to flourish. Section 230 was part of a 1996 law called the Communication Decency Act. It's worth pausing just on that. Think about where the internet and social media were in 1996 compared to 25 years later in 2021. Facebook didn't exist. Google didn't exist. YouTube didn't exist. Twitter didn't exist. The internet was nascent at that time. The Communication Decency Act did a number of things. One aspect of the Communication Decency Act in 1996 was to prohibit obscene material or sexually explicit material over the internet. A year after it was adopted in Reno versus ACLU, the Supreme Court declared unconstitutional the prohibition of sexually explicit material over the internet. The Supreme Court made it clear that the internet was a new and important medium for communication and that the law was not allowed. Subsequent efforts to restrict sexual material over the internet likely were struck down. There was the Child Online Protection Act that the Supreme Court declared unconstitutional as well. Section 230 is found in that 1996 statute. Section 230 says that internet companies, and now we think of them as social media companies too, cannot be held liable for what is posted on their platforms. So if somebody posts something defamatory on Facebook, Facebook is not liable. If somebody posts a true threat, say on Twitter, Twitter is not liable. Somebody posts a video that constitutes incitement of illegal activity. Well, YouTube is not liable under those circumstances. In essence, what Section 230 is doing is treating the social media companies like a common carrier, like the telephone. If I right now say something over Zoom that's defamatory, the Zoom company can't be held liable for what I'm saying. It's no different than if I pick up my phone and I say something defamatory in a conversation with somebody else. The phone company isn't liable. Now, if the internet and social media company play an editorial role, if they are choosing the content, then they're liable like any other publisher. But so long as they are just the passive receiver, the place where information is posted, then they can't be held liable. Think about this in comparison to newspapers. The San Francisco Chronicle is responsible for everything printed in its pages. If there's something that's defamatory within the Chronicle, even if, say, it's an op-ed, the Chronicle is liable for defamation. If there's something in the Chronicle that invades privacy, the Chronicle is liable for invasion of privacy. But Section 230 means that the internet and social media companies aren't liable for that which is just posted there. Unless they're functioning like a newspaper, they can't be held liable. Unless they're making editorial choices, they're not responsible. Why is this so important? Well, several years ago, I heard that over 5 billion pieces of information are placed on Facebook each day. My guess is it's substantially more than that now. If Facebook was potentially liable for every piece of information that anyone put there, Facebook would have to engage in extensive content moderation. They would have to review each posting to be sure that it wasn't a basis for liability. That in itself would be a seemingly insurmountable task. That in itself undoubtedly would cause Facebook to be very cautious because it didn't want to face liability. It would likely err on the side of taking things down rather than risk being held liable. So this amazing media that provides such a great opportunity for speech would be lost if Facebook had to engage in such content moderation. And this is true, of course, of all of the social media platforms. If Twitter was responsible for everything posted, every message would have to be reviewed, and Twitter would err on the side of taking things down. So Section 230 unquestionably fosters the open exchange of ideas and the free expression of thought, but it's also what fosters all of the problems that I talked about earlier. Not surprisingly, Section 230 has come under great criticism from both the left and the right. The left criticizes Section 230 because it says it's fostered media where undesirable speech can flourish. The left points to the hateful speech, the harassing speech, the bullying speech, all of which goes on. And they'd like to see regulation of Section 230 so as to hold media companies liable when there's speech of this sort. On the other hand, the right criticizes the social media companies for what they call deplatforming. They believe that the social media companies have taken down speakers like Donald Trump or Alex Jones or others who are conservative. And they believe that the social media companies are responsible for engaging in censorship. I think there's a consensus across the political spectrum that Section 230 is broken, that the internet and social media are broken, and that we need to change Section 230. But there's absolutely no consensus as to how to change Section 230. And I think the reason why we haven't seen Congress take any action is there's not a common ground between the left and the right as to what's wrong. President Trump, while still in office, very much took the conservative perspective that the social media were deplatforming. That was even before Facebook and Twitter took down Donald Trump. He vetoed a defense appropriation bill because it didn't include reforms of Section 230. Florida adopted a law just this spring that said that social media companies can't deplatform anyone. They can't take anyone off of their platform. Immediately, a federal district court issued a preliminary injunction on the ground that this regulation of social media companies would violate the First Amendment. I think that there's enormous challenges in trying to revise Section 230 so as to improve the internet and social media. To begin with, the internet and all the social media companies are private entities. Now, this has a couple of important implications. One is that if the government would go to regulate them, the government has to do so in a way consistent with the First Amendment. Because the internet and social media companies are private, government regulation of their speech, like government regulation of any private speech, has to meet First Amendment scrutiny. So if the government would order that social media companies take down hateful speech, that would violate the First Amendment because hateful speech is generally protected by the First Amendment. So any regulation has to meet terms and the requirements of the law of the First Amendment. That's why the Florida law I mentioned was declared unconstitutional, because it was deemed to violate the First Amendment. Also, regulation, the fact that these are private companies has another implication. Their choices about what to include or not include can't be challenged as violating the First Amendment. You might have seen that Donald Trump just filed suit against Twitter and Facebook and the other social media companies that took him down. They said they violated his First Amendment rights. But since Twitter and Facebook and Google are private, the First Amendment doesn't apply to their choices. The First Amendment doesn't limit what they do any more than it limits what a private company in other contexts or a private university can do. When Trump filed his lawsuit, what it said was, and I read the complaint, that because social media companies worked with the FDA about information convey about COVID, this made them government actors. That argument is nonsense. The fact that a private company works closely with the government doesn't make it the government for purpose of the Constitution. There was a Supreme Court case now 40 years ago, Rendell Baker versus Cohn, that involved a private school that received almost 100% of its money from the government. The school fired the teacher. And the question was, could the school be sued for violating the First Amendment? And the Supreme Court ruled no. The fact that a private entity contracts with the government, or receives money from the government, or works closely with the government is not enough to require that that private entity comply with the Constitution. There are other problems as well with efforts to regulate social media by changing Section 230. There's a bill that's been introduced into Congress. It has bipartisan support. It's called the PACT Act. And it says that if a social media company gets notice that speech that's been posted there is, say, defamatory or an invasion of privacy, if it doesn't take it down, it's then liable. The problem with this, again, is the sheer quantity of information that's on the internet. If anytime anybody asked it taken down, then it would create an enormous ability to censor speech over the internet. There's actually precedent for this. The Digital Millennium Copyright Act allows takedown orders to be given for material that's deemed to be a copyright or alleged to be a copyright infringement. And I think that the experience under the takedown provisions of this should make us very wary about takedown provisions applied to social media companies. So I, like everyone, searches for a way to change Section 230 in a way that would make things better, not worse. I have to tell you that all of the proposed reforms that I've seen in Section 230, I think would be much worse. I think they would kill the internet and social media as we know it. And I think it would be undesirable to do that. Now, to be clear, because they are private companies, internet and social media companies can engage in their own voluntary content moderation. Facebook, for example, engages in extensive content moderation with regard to hate speech, or speech that encourages terrorist activity, or false information about vaccines. Because it's private entities, they get to make the choices. And I don't know that we'd be better with the government regulating. There's certainly talk about trying to regulate social media companies by regulating their algorithms, the algorithms that determine which stories get what prominence. Some of the proposals that have been advanced would create more transparency with regard to the algorithms. But I wonder, even if the algorithms, computer code were published, how many people could understand it? And also, as a private company, the social media companies get to choose what prominence to give to what speech. government regulation of the algorithms, the formulas that do that, would seem to raise serious First Amendment questions. So where I am at this moment in time is I have not seen a proposal of Section 230 that I think would be desirable. The proposals that I've seen, I think, would do much more harm than good. Third and finally, I want to talk about the difficult problems that the internet and social media pose with regard to freedom of speech. And I readily admit I do not have solutions to these problems. One is the problem of false speech. Freedom of speech is protected because it has effects. If free speech had no impact, it wouldn't be a fundamental right. The effects can be tremendously positive. As I said, speech can enlighten, it can uplift. But the effects can also be terribly negative. The assumption underlying the First Amendment is perhaps best conveyed by the marketplace of ideas metaphor. It goes to John Stuart Mill, to Justice Oliver Wendell Holmes. And the idea is, let all ideas be expressed. And the hope is that the true ones will be the ones that come out on top, and that as the false ones, they'll get refuted, and the truth will emerge. I've always been skeptical of the marketplace of ideas metaphor. Why believe that truth will predominate over falsehood? And even if it ultimately does, can't false ideas create enormous harm in the interim? And given the disparity in terms of who has the ability to reach a large audience, why believe that they're necessarily the ones that are putting forth truth? And the minority of voices that may well be drowned out are false. And yet, when I think about the marketplace of ideas metaphor, I'm reminded of something that Winston Churchill said about democracy. He said, democracy is a terrible form of government, but it's better than anything else that's been devised. The marketplace of ideas metaphor seems to me terribly flawed. Why believe that from the cacophony of voices, truth will emerge? But what's the alternative? Is the alternative as exists in so many countries to allow the government to choose what's true and what's false and censor that which it deems to be false? Would we really be better off giving that power to the government? I think not. Well, the Supreme Court has taken an inconsistent position with regard to false speech in the First Amendment. I think the inconsistency is inevitable. The Supreme Court at times has said that false speech is protected by the First Amendment. Perhaps the most famous case, maybe the most important free speech case ever, was New York Times versus Sullivan in 1964. It involved an ad that was placed in the New York Times about a sheriff in Alabama. The ad was placed by civil rights protesters. It had minor factual inaccuracies, and the sheriff sues for defamation. The Supreme Court overturned the defamation liability. The court made it clear that the First Amendment limits the ability of the government to permit tort recovery. After all, courts are part of the government, and court action is state action. The Supreme Court said the First Amendment protects open and robust debate about those who hold and run for public office. The court said even vituperative attacks on those holding public office are protected by the First Amendment. In the most important language for our purposes today, the Supreme Court said there must be protection of false speech. So true speech has the breathing room that's necessary in order to thrive. The court said only if we're willing to protect a certain amount of false speech can the ideas of the First Amendment be carried forth. The Supreme Court in other cases too has said that false speech is protected by the First Amendment. There was a case not quite a decade ago called United States versus Alvarez. It involved a federal law, the Stolen Valor Act. the statute made it a federal crime to falsely claim to have received military honors or decorations. Javier Alvarez was a member of a small board in Southern California, added he bragged about the military honors he won, including the Medal of Honor. All of it was untrue. He got prosecuted for violating the Stolen Valor Act, but the Supreme Court, in a 6-3 decision, declared the Stolen Valor Act unconstitutional. Justice Kennedy, writing for the plurality, was explicit that false speech is protected by the First Amendment. He relied on New York Times versus Sullivan and the need to safeguard false speech so there can be the breathing space for expression to thrive in the United States. And yet there are times that false speech is not protected. Lying under oath in court, perjury, is not protected by the First Amendment. False and deceptive advertising is not protected by the First Amendment. Well, what do we do with false speech over the internet? Do we simply have faith that the response should be more speech and that the truth will emerge? Or should we give the government more power to deal with false speech over internet and social media? This became so crucial over the last year when false information about the threat of COVID-19, false information about vaccinations so took hold on the internet. Should we have put our faith that the responses to that would ultimately win out? Or should we have given the government more power to deal with false speech? If you go back to what I said at the beginning of remarks, the internet makes it possible to transmit speech more quickly, more effectively, more cheaply to a mass audience than has ever existed before. But that also means it could be false speech that's transmitted in that way. Another problem, that's also something I alluded to, is the problem of foreign interference in American elections. Foreign countries, through the internet and social media, through the use of bots, can certainly have tried to influence the outcome of elections. How can we regulate this, if at all? One complication is the United States Supreme Court has been clear that the government can't regulate speech based on the identity of the speaker. In Citizens United versus Federal Election Commission, the Supreme Court explicitly said that corporations could not be treated differently from individuals when it comes to the ability to spend money in election campaigns. Justice Kennedy's majority opinion very much rejects speaker-based restrictions. And if we were to try to put limits on speech by foreign countries, isn't that a speaker-based restriction? The assumption, as I said, of the First Amendment is that more speech is better. Can we say that's not true if the additional speech comes from foreign countries? And how are we going to enforce law? How are we going to know what speech is from a foreign country and what's in the United States? I think we all find it uncomfortable that a foreign country like Russia could play a decisive role, potentially decisive role, in a presidential election. But nor has somebody come up yet with a solution to this. It's a problem that's so much a function of the internet. So what I've tried to do is to sketch out what I see as crucial benefits and problems from the internet and social media when it comes to democracy. I think our democracy is more in danger than it's been at any time in American history. On January 6th, for the first time since the country was formed, there was an attempt at a coup, an attempt to overturn the results of a popularly elected election. There's no doubt that the internet and the social media played a huge role in this, a huge role in spreading falsehoods about the election, a huge role in bringing people to Washington on January 6th for the insurrection. But I also worry that to blame the internet and social media for this is to blame the messenger. In fact, I think a lot of the criticisms of the internet and social media or blaming the messenger. There are deep problems in American society. The internet, social media reflect these problems. I think they reflect more than their cause. I've always taught my students that the only way that your speech or my speech can be protected tomorrow is to safeguard the speech that we don't like today. I've always told my students that the First Amendment is based on great distrust of government power. Are those assumptions still true today? In light of the new media, the internet, social media companies, what is the future of American democracy? What's the future of democracy in other countries? There is no easy answer to these questions, but they're ones that we all need to struggle with and struggle with now. With that, I've talked my 45 minutes and I'm glad to take questions. I see that there, I think some in the chat. No. If you want to put questions in the chat, you can. If you want to raise your hand, you can. Whatever you want, I'm glad to take questions.
It would be great. We don't have the ability, if everybody could please put their questions in the chat, that would be great. And we have about 10 minutes for questions. So looking for you to type your questions into the chat, please.
While we're doing that, I can tell you, there aren't any cases this term before the Supreme Court that deal with internet or social media. There's a lot of lower court cases that are fascinating. I think the real question, as I alluded to, is whether there could be some bipartisan effort in Congress to change Section 230, but it certainly hasn't begun to happen yet. There's somebody with a hand raised. Maybe that person could type the question in the chat.
Trying to see who that is.
I see it. I can read it. It says Angelo Costello.
Angelo, can you type your question into the chat for us? There we go.
Why can't the internet be guided by the same restrictions as broadcast news companies? Don't they all have licenses which are subject to government review? To start with, broadcast companies have licenses because of the need to make sure that there's only one broadcaster on a particular frequency at the same time. So Channel 2 gets its frequency. Channel 4 gets its frequency. Channel 5 gets its frequency. Or you can think of your radio dial. Each of those stations gets its own frequency. And it has to be that way. And everyone else besides who has the license is prohibited from using that frequency. Because if there were multiple people broadcasting on the same frequency as AM 570, well, nothing could be heard. If there were multiple TV stations on Channel 2, nothing could be heard. It would truly be babble. There is no licensing of internet or social media companies. You or I, Mark Zuckerberg, or anyone else could create our own new Twitter or Facebook or platform. And the reason is there's not frequencies that need to be allocated by the government. The Supreme Court has allowed restrictions on broadcasting because the government issues the license, but the government's not licensing internet companies. Now, I probably should have been clear. Speech isn't absolute. Speech that's incitement of illegal activity or obscenity or child pornography or false and deceptive advertising can be prohibited and punished. And that's true on the internet as well. It's just that the internet companies can't be held liable for that because of Section 230. Does a public official have the right to block someone on social media? So far, the lower courts have said no. There isn't yet a Supreme Court ruling. President Twitter attempted to block some people from being on his Twitter following by saying that this was his own platform and he should be able to do it. But the lower courts ruled against President Trump and said he was using his Twitter for announcing official positions of the government, and that therefore it was a government forum and he couldn't exclude people on that basis. An analogy is there have been efforts sometimes by city councils or mayor's offices, maybe in state legislatures, to deny credentials to particular newspapers or reporters who are seen as hostile. And the lower courts have all said, no, a city council and a mayor, if they're giving reporters privileges, can't exclude on the basis of content. Well, likewise, the lower courts have said so far that elected officials that have social media platforms that they use to discuss government business can't exclude others. So far, the courts have been consistent in that regard. I'm reading, as a former small town newspaper reporter and former Bay Area libel reporter, I grew up at a time when crazy couldn't get all together in public. The internet has made it easier for hate groups we'd have rejected in smaller groups to get together out of light in the day. How can we affect the ability of the internet to give a megaphone to hate groups? I don't think there is a way at this point. I mean, other than the social media companies can choose on their own to not carry the hate groups. Let me explain why. The Supreme Court has generally said that hate speech is protected by the First Amendment. I'm often asked, where's the line between hate speech and free speech? And under First Amendment doctrine, hate speech is protected as free speech. There's a Supreme Court case, 1992, RAV versus City of St. Paul. St. Paul, Minnesota adopted an ordinance prohibiting burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. And the Supreme Court unanimously declared that unconstitutional. So I don't think that the government can prohibit speech on the internet just because it's hateful. But, and this goes to something I said in my remarks, the internet companies are private companies. They don't have to comply with the First Amendment. The internet companies can, and often do, take down hateful speech. And we can pressure them to take down hateful speech. But I don't think the government can require that they do so. I think that would violate the First Amendment. By some decisions of the United States Supreme Court since Bush versus Gore, and particularly in Dichter, we've seen many of the justices would uphold the right of state legislatures to toss out votes. Can you address that subject? The Constitution says that each state legislature shall decide the means for allocating that state's electors. In 2000, in Bush versus Gore, Chief Justice Rehnquist and Justice Scalia and Thomas wrote an opinion that was concurring, where they said that the state legislature gets to decide, not the state courts who gets the electors of that state. And the argument was raised in the 2020 presidential election that the courts of a state can't determine who gets the electors, that it's only for the state legislature. This was an argument made in Pennsylvania. Pennsylvania had extended the time for absentee ballots, and the argument was this is inconsistent with the legislature getting to decide. The Supreme Court denied review on that basis. In the arguments made, well, then if the legislature wants to, the legislature could ignore the popular vote and give the electors to whoever they want. I think it would be tragic if a legislature chose to give the electors to somebody other than who won the popular vote in the state. But whether there's now a majority on the court to accept that argument from Bush versus Gore is uncertain. I think courts have to be able to interpret state constitution and state laws so as to protect the right to vote. I don't think that you can take that power away from them, but that's certainly what the argument would try to do, saying it's only the legislature. Any thoughts on Justice Thomas's opinion the New York Times Sullivan should be overruled? I think of New York Times versus Sullivan as perhaps the most important free speech decision ever. After all, it's the one where the Supreme Court said the First Amendment protects open and robust debate. It's where the Supreme Court said even false speech is protected. It's where the Supreme Court limited the ability of public officials and those who run for public office to recover for defamation. The day after it came down, then University of Chicago law professor Harry Calvin said it was an occasion for dancing in the streets, and it is the foundation for libel law. To just give you a simple example, in England, the defendant in a defamation case must prove truth. Under New York Times versus Sullivan, the plaintiff in a defamation case must prove falsity. And that makes a huge difference in the speech we can get. But a couple of years ago, in the denial of certiorari in McKee versus Cosby, Justice Thomas wrote an opinion for himself calling New York Times versus Sullivan into question. Last spring, Justice Gorsuch joined Justice Thomas in calling New York Times versus Sullivan into question. It's still just 2. Doesn't seem to me to be anywhere near a majority to reconsider New York Times versus Sullivan. But for advocates of free speech, New York Times versus Sullivan is canonical, and it being called into question is something of concern. Is the internet something qualitatively different from more traditional forms of media? Absolutely. I believe in the way that it allows all of us to reach a mass audience. Tremendously different. I know law professors that have over 1 million Twitter followers. Prior to Twitter, that person would have needed to have a broadcast license or own a newspaper in order to be able to reach 1 million people. What's on the internet is really there forever. That's different than traditional media. The internet transcends national boundaries. Those were my points earlier, and I think it does make it totally different. I think I have time for one more question. There's now again talk about changing the court's composition after the former Republican president packed the current court with justices, rather far on the right ideologically. What do you think will happen? I'm glad you asked me, what do you think will happen? And the answer is nothing. The number of Supreme Court justices is set by statute, not by the Constitution. It can be changed by federal statute. But in order to change it, it would have to pass both the House and the Senate. Even if the House were to pass a bill to change the number of Supreme Court justices, there's no way it's going to get to the Senate. We know it would be filibustered in the Senate. And we know that there's key Democratic senators like Joe Manchin who won't overcome or change the filibuster. So I don't see any change in the composition of the court. It says, the last time you spoke to the CCCBA, you had some real insights regarding the new conservative court. Has your opinion changed in any way as you've seen more things, of course, more liberal rulings? Last term, every divided case came out in a conservative direction. There were a couple of liberal rulings where the court was 8-1, a case about student speech. But the reality is, if you look at the cases last term, cases about voting, cases about taking of private property, cases about the sentences that can be imposed for crimes committed by juveniles, cases about habeas corpus, they were all 6-3 decisions with the 6 justices in the majority. But it's this term where abortion rights, gun rights, separation of church and state are all before the court. That's where I think we're going to see how conservative is the newly constituted Roberts Court. And maybe you'll be kind enough to invite me back next year and I can talk about it.
Well, thank you very much. We are always happy to have you back. Thank you again for coming today and offering us your insights. It's just one more wonderful topic. Thank you very much. And I know you have a hard stop and need to run. So thank you. And we will look forward to having you back again.
It's
Anytime.
truly my pleasure. Thank you so much.
Thank you. Okay, everyone, that was great. Thank you very much. Just want to remind you that we do have a marketing forum at 2 o'clock today, if you're interested, put on by our CCCBA pros. And then we have a full slate tomorrow of programs. So we look forward to seeing you again tomorrow. And thank you very much for joining us today.